My name's Simon Offord. I'm an attorney with the law offices of Peter Brewer. I have been with Peter Brewer's office for 7 years now, and all we do is real estate law primarily. We do both litigation and transaction, and over the last few years, we've had a lot of these cases come in. I've taken one to trial. A lot of them, fortunately, do get resolved pre-trial, but they're always coming in our door. It's a popular area right now for law. That's especially true with all the construction that we're seeing more recently. The boom in real estate, especially here in the Bay Area, has caused a lot more of these easement disputes to arise. When people do construction, they start to notice their property lines are wrong, or there's an easement they didn't know about, and that causes some of these disputes. In front of you now on this slide, we have our disclaimer. The advice and the opinions I'm giving today are not intended to be legal advice. They're actually just informational information. Every circumstance is different, and easements are a very big issue. And so what I'm telling you today is the basic law, but whether that law applies in your particular situation is going to be dependent on the circumstances. Again, Simon Offord with the law office of Peter Brewer. We're going to start today with the basics of easements. We'll talk about the definition of what an easement actually is, the characteristics of an easement, and then formation. Formation is the purely legal side about how you actually can obtain an easement, or how you know if you already have an easement or are burdened by an easement, frankly. So let's start off with the definition. What is an easement? Well, an easement in the legal definition sense is a non-possessory interest in someone else's property. Generally, every easement has a dominant tenement and a servient tenement. The dominant tenement is the party that is being benefited by the easement, and the servient tenement is the person that is actually being burdened by the easement. So, for instance, if you have an easement over someone's property, the dominant tenant is going to be the person that actually gets to drive over the property. The servient tenement is the person that's burdened by it. Try to avoid using the dominant tenant, servient tenement, because frankly, it's a little bit outdated language and it can get confusing. But the point is that there are always going to be at least two parties that are involved in an easement. And it's important to understand that an easement is an inherently shared use. And we'll get into this a little bit further on later. But easements generally, and the purpose of easements is that they are shared. You're giving someone a specific right over your property, not necessarily an ownership or anything beyond some sort of shared use. There are, of course, exceptions to that we'll talk about. And, of course, it is an encumbrance on title. Assuming that you have already obtained an easement, whether it's by an express grant or whether it's somehow judicially created, the easement is going to be an encumbrance on title that will show up in a title report. Until you actually have the encumbrance, you don't have a transferable right. So the title reports will show you whether the easement does exist on the property. And again, as I mentioned earlier, the easement's a shared use. This is a critical element of an easement, and it helps form some of the legal principles we'll talk about later on today. All right, the basics. So what we will discuss is the type based on how it's created. So we'll talk about all the different ways of creating easements, from the express to the judicially created. Those judicially created easements have a set of elements in order to establish them to prove that you have a right to an easement. Generally, once you have the right established, whether it's expressly, meaning someone granted you the easement, or it's judicially created, it's going to be recorded in the public record with either a grant or a document granting the easement, or alternatively, a judicial decision or a judgment saying that you have the easement. As mentioned before, again, it's an encumbrance on your title, and it's going to be a shared use, typically. Again, typically on the shared use issue. We'll get into that later on. All right. The range of easement rights is significant. This list is not intended to be all-inclusive. These are just some of the more common types of easement rights you'll see. So as you can see, probably the most common are the first two listed, the access easements and the utility easements. You wouldn't be surprised that most properties have some sort of utility easement over them, whether it's to benefit a neighbor or it's a public utility right. And access is also very common, especially in rural areas. The next three, light, air, and view, are interesting form of easements. We have a specific slide dedicated to those later. But you can obtain an express easement for light, air, or view. So, for instance, you have a coastal property and you want a view of the ocean. Your downhill neighbor can grant you a view easement. Parking easements we see on occasion. This is especially true in homeowners associations, or if, for instance, you have an access easement, you can also have an easement to park along the access easement. Maintenance easements are common. Commercial properties oftentimes will have maintenance easements, and homeowners can have maintenance easements. So, for instance, if you have a retaining wall that's encroaching on someone's property, you might also have an easement where you have a right to enter their property to maintain that retaining wall. So, sometimes when you're crafting an easement, it's important to think of, okay, do I need anything else other than just the access or just the retaining wall? Do I need a right to enter the property to maintain those items? Water rights are common in easements. That could include anything from running water to the property to issues with diverting water or the right for overflow or flood water to go into someone else's property. Again, that's more common in a rural setting. Fishing and recreation, hunting type easements are also common. You can have a right to go onto someone's property for limited purposes of fishing or hunting or some other sort of recreation. Support easements, again, that kind of goes hand in hand with the retaining walls. You can have an easement for some sort of underground support for your property. You can have easements for retaining walls. The next two also go hand in hand. Fences and party walls, you can have an easement for a fence on someone else's property, or a party wall, which is essentially a wall that's a dividing fence. And then last is exclusive, and we have an asterisk by exclusive because this is a kind of interesting area of law, where we talked earlier that easements are generally a shared use. And so when you're trying to create a judicially created easement by proving the elements of prescriptive easements or equitable easements, as we'll talk about later, the idea of an exclusive easement is contrary to how easements generally work. So exclusive easements are harder to get in a judicially created situation. However, in an express easement, which again we'll talk about how these work later, it is possible to give someone an exclusive easement. Sometimes that's something that people do in lieu of a lot line adjustment. It's cheaper, it's easier to do, it's quicker, but there are pitfalls in that. And I can talk about that a little later. Okay, what easements are not? Well, easements are not ownership. This is a key thing to understand because an owner has more rights than an easement holder does. So, and they also have more burdens. So, if you own the property, you have to pay the taxes on the property you own. You have to be responsible if anyone gets hurt or injured on that property, and so you need to have insurance for the property that you own. Easements are a little different. If, for instance, you had a driveway on someone else's property, an access easement, you don't actually own the driveway or the land under it. You just have the right to use it. So, in theory, unless the easement language dictates otherwise, you're also not paying taxes on it. And so, for the burden, the homeowner, the one that has to be going over the property, they need to think about that if they're going to consider granting an easement to someone. Because if someone gets in a car accident on the driveway or hits another person, that's on your land. And so you might have some responsibility there, or you might get brought into a lawsuit because of that. So it's important to make sure when you're considering granting an easement that you think about all the elements and all the risks that you could be facing by granting someone that easement, and then crafting ways to protect against that. We'll talk about that a little bit later as well. Okay, next, characteristics. So the types of things you'll generally see in an easement agreement include things like maintenance. And so, for example, in the driveway issue we talked about earlier, well, who's responsible for maintaining the physical driveway? You want to address that up front in the easement, ideally, to avoid any disputes later. The next is going to be the legal description. It's always best to have a very clear description of what the easement is. There are cases that talk about easements that literally say you have a right to use a portion of the neighbor's land. Well, what does a portion mean? That's a very unclear thing. So if you're able to have a specific legal description prepared by a surveyor, that makes it very obvious to everyone what exactly the easement contains and what area it is in. The next thing that you want to have in a typical easement is the scope or the extent of the rights. So you want to be very clear about what specific rights are being given to someone. Is it just limited to access, or is it also access plus the right to run utility lines? Or is it also the access plus the right to use utility lines plus to park on the strip or the driveway? So those are all things that should be worked out and clearly defined in the easement. Next are restrictions. So are there any restrictions on the use? Can it only be used at certain times for certain amounts of time? Any other kinds of restrictions should be placed and clearly put in the actual draft easement. And lastly, protections. Like I just talked about, if you own the land and something happens on that land, say for instance, again, the driveway, you want to make sure that the actual benefited party, the one that's using the driveway, has agreed to indemnify you and add to their insurance policy and otherwise protect you if anything happens because of their beneficial use of your land. Okay, now we get to formation. How are easements formed? Well, there's two main ways that easements are formed. One is you can expressly grant one from an owner to another owner. And then the next way they're formed is typically by judicial creation. So a judge will form them if you can prove the elements. Now, easements are an equitable issue, and so a small claims judge, for instance, cannot grant an easement. So if you're trying to sue someone to obtain rights over their property, you actually have to go through the full process of a either limited or unlimited civil case. You can't simply go to small claims court. So getting an easement can be expensive from a judge because it's not an expedited process. You have to have a full-blown legal proceeding. Of course, as in with any case, you can file a lawsuit and resolve it on your own. And as part of the settlement, one owner can grant an express easement if they're convinced that the other party will be able to prove to a court that they have all the elements met to get an easement by necessity or prescriptive easement or equitable easement. So that is how a lot of the cases settle, is by the grant of some sort of easement or the purchase of an easement. And although those are technically going to be express easements, the only way you're going to be able to convince another party to grant you one is if you can show them that you can prove elements. And so in a few minutes, we'll talk about all the elements for the main three easements that we see in California, which are an easement by necessity, a prescriptive easement, or the newest created easement, which are called the equitable easements. Okay, so the first question is, can an easement be obtained? Like I said at the beginning of this webinar, this is a very fact-specific determination. There's lots of factors and elements that go into these easements, and so whether you can get one is going to depend on the specific facts of your case. Also, it just depends on the cooperation of the property owner. If you realize that you don't have an easement or the easement isn't as inclusive as you thought, or you've been using property for 60 years because you thought it was yours and you want to get an easement, well then it's going to some extent depend on the cooperation of the next door neighbor in most instances. Are they willing to work with you to try to get it created or not? And if they are, then it's a lot easier. If not, then you need to prove that those easement elements that we'll talk about in a few minutes are met to a judge. Okay, so as mentioned, the types: express, necessity, prescriptive, and equitable. Let's start with express. So express is the simplest type of easement. It's one where one owner will specifically grant an easement to another by way of a written instrument that is recorded. Express easements are going to be found on a preliminary report or any title report because they run with the land. And so in order to find an express easement, you should be able to find it when you do a simple title report. These are probably the most common type of easements. A lot of times when you have for instance, developer creating a subdivision, the developer will know in advance that, okay, we need utility easements over these properties. People grant these easements to each other. And a lot of times these easements have existed for years, since before the property was built. So those easements are pretty common, and those are the most typical ones you're going to find if you're, for instance, purchasing a property and you're looking at a preliminary report. Okay, next. A lot of these express easements have been attached to the property for countless years. So, for example, if you buy a property in 2016, but the property was built back in 1920, there's a good likelihood that there's an easement on the property that was expressly granted back in the 20s. And over the last 100 years, circumstances may have changed. So, what happens when you have an express easement that's ambiguous or unclear? I believe it was 2 years ago, a case came down. It's the Rye versus Tahoe Truckee Sierra disposal case. And this was a case where there was an easement granted, and it specifically said it was an easement for something along the lines of driveway, storage, and parking over, quote unquote, a portion of the lot. Okay, well, what does that mean? Like I talked about earlier, it's always good to have a very clear definition of the scope and the space and the type of easement. Well, in this case, you had it pretty clear what the scope was, but what the location was completely unclear. It didn't say even over the northerly portion of the lot or over the westerly portion or 5 feet from the property line. Nothing like that. It just said a portion. So the court said, well, the only way for us to interpret this easement is to look at the permissible use that was historically used by the parties. So the goal of the courts is to try to understand the intent of the parties. Well, so the only way you can do that is actually to look at the historical use. And so the court looked, and there was a driveway, a gravel driveway that had been used over the years. And so the court determined that gravel driveway was the extent of the express easement because the benefited party didn't use any other part of the lot. And so that would suggest to the court, well, that's what the two parties intended for that easement to mean. And so a lot of times there can be disputes over the interpretation of an express easement. And so that's when you have to look to the history and figure out, okay, what did the parties really intend here? Here we have an example, a diagram of an express easement. So this is a common type of easement that you will see in a lot of properties. A utility here in this case. So we're looking at, in this example, it's a water easement. So if you're off of the street or down the block in a complex or a subdivision, you're going to need a right to run utilities to your property. So the owner of the property between you and the utility line will grant you an easement that will be under your property essentially to get to home so that you have a right to that easement over their property. That is a very, very common express easement. And here in the diagram you see the area boxed in orange is the area that has been granted as the express. Okay, the next type of easement is the easement by necessity. Now we're moving into the judicially created types of easement. So an easement by necessity is an easement that's necessary for the owner to gain access to his or her landlocked property. The elements of an easement by necessity are listed here on the slide. You have to have two parcels that were previously under common ownership. This is the hardest part about an easement by necessity to prove. The two lots have to be commonly owned at some point. So if you have a subdivision of lots and the subdivider basically just forgot to grant an easement for access to the back lot if it's off the street, then you can get an easement by necessity. But if you just own a lot and it was never under any sort of common ownership and you just happen to be neighbors and you don't have a right to access, well, then you can't get an easement by necessity. We'll talk about equitable easements a bit later, which will give you your backup option. But historically, easements by necessity were the only way to get an access easement if you're landlocked. And again, it requires an actual physical landlock. So if you're litigating an easement by necessity case, you'll typically need an expert witness that will be able to say, for these reasons, this is the only way that you can get access to this property. For instance, if the grade on all three corners of the property is so steep, or if there's mountains, or if there's some sort of waterway that a bridge can't be built on, or there's some sort of city or county restriction to having a driveway in the area. These are the kind of things that would make you landlocked, and you have to actually prove that you are landlocked. And here we have the example of an easement by necessity. Again, the back property is landlocked by mountains. So they need an easement across the front property to get to their property. And so an easement by necessity would grant you the right that's boxed there in orange on the diagram. Next, we have prescriptive easements. Prescriptive easements are a very common type of judicially created easement. They're one of the things every law student learns about in law school because prescriptive easements are available in many states. The specific elements change per state, but we'll talk about the elements in California. But in any event, a prescriptive easement is a non-owner can acquire a right to use land based on the time and the nature of their use. So the specific elements of a prescriptive easement are 5 years of continual use. Use has to be open, notorious, and a visible possession. It has to be hostile and adverse to the owner, and it has to be under a claim of right. So let's go through each of these elements. The first is the 5 years of continual use. Other states require longer time, 10, 15, even 20 years. California, it's 5 years. And what does continual use mean? Well, continual use is fairly broadly interpreted. There are cases where there are instances where someone goes onto someone else's property to camp or to hunt or to fish only once or twice a year, but it's continuous every year. So it's something they kind of annually or biannually do. The courts have said that is considered continual use. In other circumstances, such as an access issue, for instance, you walk across someone's property to get to the beach. Again, it's not something you have to do every single day. You just have to kind of do it in some sort of continuous and regular manner, and that could be only once a week or once a month. But it doesn't mean it has to be something that you're doing every single day for a number of hours a day. No, it's a much broader definition of single. Next is open, notorious, and visible. So it has to be something that is visible by an outsider, that you can see that they're using the land. This is typically a pretty easy burden to prove. The only time that a prescriptive open and notorious use is difficult to prove is, for instance, in like a utility easement because it's underground and you can't see it. Next element is hostile and adverse to the owner. Okay. This element has caused a lot of confusion, and it sounds like it requires a lot, but what it requires isn't as significant as it seems. Excuse me. Hostile and adverse essentially means that it just has to be adverse to the rights of the true owner. So you don't have to go over there yelling and screaming every time you use it in order to establish this hostility. No, it just has to be against the true rights of the owner. So virtually any use of someone's land is going to be hostile unless you have permission. And so what we'll talk about in a couple of minutes here, what that means and what permission does and how to actually defeat the hostile claim. And there are specific statutory methods to do that and practical methods to do that. And then last is under a claim of right. Over the last decade or so, the courts have somewhat eliminated this element. It basically falls in the same parameters as the hostile and adverse element. Again, you're using it adverse to the claims of the owner. A prescriptive easement doesn't require knowledge that you're actually improperly using someone else's land. So because of that, this hostile and adverse and under the claim of right elements have kind of merged into one. Now, how do we prevent someone from gaining a prescriptive easement? That's a big issue because 5 years is not a long time, and it's fairly easy to establish these prescriptive easement rights, especially if it's someone that owns a property that they maybe don't have a house on, it's just a piece of land. So let's look at the example here, and we'll get back to that other slide. So here's a common example. You have a beachfront property or any property that's located next to some desirable place that people want to get access to. And the question is, how do you stop someone from getting a prescriptive right to walk across your property to get to the beach or the park or the school or whatever it might be? Well, there's a few options. One, you stop them from physically being able to get to your property, so you build a fence or a wall and you lock it. That's one option. The pitfall with that option is then if someone uses it, it's clearly hostile and adverse because you block them permission. So you're not giving them permission. That means that doing that is definitely going to meet the hostile and adverse claims. That being said, just blocking access and making it a significant hurdle to actually physically get on your property and get to the beach is an easy way to deal with it. And the next thing you can do is there's Code Section 1008. The Civil Code Section 1008 states that you're allowed to put up right to pass by permission signs along the property. And those can either be at the entrance and the exit or every 200 yards along the property. By putting a sign that says you're using my property with a right permission, then that takes away the hostile and adverse element. And so it makes it impossible to get the prescriptive easement. The issue then is you might be encouraging people to actually cross your property. So if your ultimate goal is to keep people off the property, that's not ideal. But if your goal is just to avoid some permanent right being established, then the Civil Code Section 1008 signs are helpful. And then there's a specific code section, Civil Code Section 813, that deals with coastal properties. So like in our example here. And similarly, coastal properties, you have a way and you can record a document that says that the public doesn't have a right to cross your property to get to the beach or the coast. This civil code section does not prevent against individual trespassers and individuals getting prescriptive rights though. So for example, if just the person across the street from you walks across your property every day to get access to the beach, the Civil Code Section 813 remedy won't help you there. It's just meant to prevent against the public claiming some sort of right to cross your property. Okay, going back one slide, prescriptive easements. This is a critical part of prescriptive easements, and there's case law on this issue that there's no such thing as an exclusive prescriptive easement. Again, going back to the beginning of the presentation, where we talked about the fact that an easement is inherently a shared use. So the idea of having an exclusive prescriptive easement would be cutting against the basic purposes of an easement. And so there's a case that says, quote, garden variety fence disputes, unquote, do not equal a prescriptive easement. So what is that talking about? Well, that's talking about the kind of case where you have a fence that's misplaced, say 5 feet on your neighbor's property. So you're getting the use of 5 feet of their property. Well, if you've had that for 5 years, does that mean that you have a prescriptive easement now and you get to use that 5 feet of land in the same manner as you did before? No, it doesn't, because that would be exclusive, and that's not the purpose of an easement. And so the other important thing to understand about prescriptive easements are that prescriptive easements are created based on the historical use. So if you bring a case for prescriptive easement saying that you've been walking across this person's property for the last 10 years to get to the beach, the most you're going to be able to get is a continued right to use the property to walk across it to get to the beach. You're not going to get a right to then ride your bike or ride a horse or drive. No, it's limited to the prior use. So you can't try to expand a prescriptive easement. You can only get how you've been using it as if you've met those other elements. We'll talk in a few minutes at the end about adverse possession, which is very similar to prescriptive easements. The difference being that you actually get an ownership interest in the other person's property, and there's an important extra element that's required in order to prove adverse possession. It's very difficult to do. Okay, and there's again our example of prescriptive easement. And then the last type of judicially created easement, or commonly judicially created easement, is the one that gives us real estate attorneys the hardest time. And these are the equitable easements. And equitable easements is a situation when the court exercises their equitable jurisdiction or power to grant an easement when grounds for the other easements that we talked about earlier do not exist. Okay, equitable easements are kind of a new thing in the law. And by new, it means they've been around for almost 30 years now. But in the world of law, that's actually a relatively new concept. There's not a ton of cases on equitable easements. And so equitable easements are a very difficult thing for us as attorneys to predict the likelihood of success on, because they're solely based on equitable principles and what that particular judge on what that particular day thinks is fair or not. So the elements of an equitable easement are the party used and improved the area they're seeking to obtain an easement in. This is a key one. They had an innocent belief of the right to use the land. So, and we'll go over these in more detail. There has to be some irreparable harm to the parties seeking the easement if they do not get to continue using the land. And finally, the impact of the affected owner has to suffer little harm. So the first element requires some sort of substantial use and improvement of the easement. So you can't just say, well, I looked over that land and I thought it was mine, so I get an equitable easement. No, you have to actually improve it. Build a driveway, build walls, accidentally build part of your structure on the area. It has to be some sort of improvement. The innocent belief is key. So you can't obtain an equitable easement knowing that you're building or using someone else's land. It has to be based on an innocent belief. And then the last two elements are, to some extent, a balancing test. However, a recent case clarified that balancing test maybe isn't the best word to use because you have to have a significantly disproportionate harm to the person seeking the easement versus the impacted person. So it's not a clear balancing, it's actually a significant harm to the person seeking the easement. And again, this is where difficulties in predicting what could happen come up, because to one person, what would be a significant hardship can be completely different to a different judge. And so equitable easements are very hard to predict. And in litigation, you never know what's going to happen at the trial level for one of these kind of easements. A common example for an equitable easement is what we have here on the diagram. So you have two pieces of property adjacent to one another. And let's say the owner of the house on the left, let's call that owner A, has a fence that's been in place for 50 years that's encroaching on the neighbor's property. And all along, when they purchased the property, the fence was there. They assumed, okay, the area included by the fence must be mine. And they build a pool or a pool house like we have here, or retaining walls or a driveway or some other significant improvement. And then house owner B, 50 years later, is deciding they're going to remodel their house. They go out and get a survey and they find, oh, this fence is way off. And then so owner A is going to say, well, I'm going to ask the court for an equitable easement because I didn't know that. I put a lot of money building this pool here, and it's going to be unfair for me to have to fill in this pool, remove this pool house, or lose my driveway or whatever it may be. And so the court will look at whether they can prove it was innocent. The court will look at the harm to the owner of the land versus the benefit or the hardship that the owner of the person seeking the easement is going to have, and take a look and determine that. A lot of times, if there are significant improvements like a pool or a pool house or something of that sort, the court, and it's been there for a long time, the courts will grant an equitable easement, but they'll make the person pay for the value of the use of that land. Courts can also say the equitable easement is limited in time to the owners of the two parcels, because when owner A sells, the buyer will know, oh, actually, you don't own this. So then all of a sudden the balancing shifts a little bit. So equitable easements can create a wide variety of results that are very unpredictable. And it makes those a little scary for us as attorneys because we like to be able to at least tell our clients somewhat what we can expect in a trial or in a decision. Earlier, we talked about the easements by necessity and access to a landlocked property. Well, the easements by necessity doctrine has been somewhat eroded by this newer concept of the equitable easements. There's a few cases, the Tasha Corey case being the most significant one, has somewhat obviated the easement by necessity doctrine, because in that case, there was no co-owned parcel. So one of the elements of easement by necessity was gone. But then the court said, well, even though easement by necessity is not possible, looking at these equitable easement factors, we think it's unfair that this person doesn't have the right to use the driveway. The parties both use it. It's a shared use. It's only one property. It's not a big hardship. So we're going to grant it. equitable easements for driveways, there's been more and more of those cases coming out. And so it's a little frustrating as attorneys because, again, we're losing an element of assuredness, and it becomes more of a guessing game as to is this equitable or not. It's very hard to predict what one judge is going to say. And so now even these equitable easements and easements by necessities are hard to distinguish, and it's making it even more difficult to predict what's going to happen. So that always benefits trying to resolve these things informally, because you might not like what the judge is going to eventually do, given they have these extremely broad equitable powers. The other issue with equitable powers are they're very hard to overturn on appeal. So if you don't like an equitable easement that's granted, getting that changed is very difficult. Okay, so now that we know how easements are formed, let's talk a little bit about the disputes that can arise in easements. The first is overburdening or using the easement outside of the scope of the permitted use. So again, in order to resolve these kind of disputes, we need to look at the scope of the easement and what specifically is in the document. What does it allow? Is this just an access easement, or do they also have a right to run utilities through that area? Is this just an access easement, or do they also have the right to park on the driveway? Those are questions that will need to be answered by first looking at the easement itself. And if you can't get an answer there, then you need to look at the historical use generally. And again, different kinds of easements are going to have a different analysis of this. So it's very fact specific on the type of easement that you have. A light air easement versus a maintenance easement versus an access easement, they're all going to be very different in these things. So in order to determine the scope, you need to know the specific kind of easement you're dealing with. Next is whether an easement has been abandoned. There are instances where one person hasn't used an easement for 20 years. So say, for instance, you grant an access easement to someone over your property, but then they go ahead and build another driveway on the other side of the property. Well, then can you say, well, you don't need my easement anymore, so you get it? The answer is generally no. It's difficult to establish that an easement has been abandoned. The elements that are listed here, you have to have non-use. Okay, so that one's probably pretty easy. In the example we just had, say they never use the driveway or they block it off, that's easy. They're not using it. The difficulty becomes in the second element, which is an intention to abandon the easement. So the benefited party has to actually have an outright established intention to abandon the easement. So if they say pull out the driveway and build up a wall where the driveway would have been, that's getting closer to an intention to abandon. But if they just don't use it, or they forget about it, or they use a different easement instead, that's not an intention to abandon. That's just picking a different priority easement to use. So that doesn't count. And then finally, you have to show that the damage to the owner of the serving estate from the continuous existence of the easement. So this means you can't simply say, he's not using it anymore, he doesn't need it. No, you actually have to show some sort of damage. And so abandoning easements is difficult. You can always obviously negotiate and offer to pay someone to abandon or expire the easement or cancel the easement. But getting a judicially created easement abandoned, or strike that, getting an easement abandoned by a judge and proving these elements can be difficult. Again, very fact specific, but it's not as easy as they just stop using it, they don't get it anymore. No, it requires more than that. The next type of dispute are air, light, and view easements. This is an area that we commonly see, and it's something that people commonly desire and think they might have a right to. So again, let's say you have an ocean view and you've had the ocean view for 50 years. Does that mean that you now have gained some sort of prescriptive rights to keep that view? And the answer is no, unfortunately. There is no inherent right to an air, light, or view easement. So you can always get one. Again, an express easement for air, light, and view is totally permissible. But you don't have an inherent right just to get one because you had one before. So if someone's trees grow taller than they used to be, unless there's some other reason why that's improper, like a spike fence or it's in violation of some sort of county code or city code or something like that. You can't force them to cut the trees down to give you your sun back or your view back. This is an unfortunate matter, but that's just what it is. So people oftentimes will buy a view easement from their downhill neighbor, and that's something that can always be negotiated, but you're not going to be able to force one. Okay, so shifting over to kind of understanding easements, well, the place you're most often going to see them, so this is for our attendees that are home buyers or real estate agents, is on the title report. So whether it's a judicially created easement or whether it's an easement that was expressly granted, it should come up on the title report. And nowadays with the title companies linking all the encumbrances, it's very easy. When you get the title report, you click on the link and see what exactly the easement says. So that's obviously the first thing you're going to want to do is review the easement. If it's an express easement, what is it for? Does it have any restrictions or protections? All those kind of characteristics we talked about earlier. If it's a judicially created easement, is it one that's permanent and runs with the land, or is it only temporary to those owners? How long does it last? Are there any, again, protections or liabilities with it? So you're going to want to read through that to understand it. And then the last thing, if it's something that appears to be of concern, and there might be some dispute over the use of it, you want to find out how it's been historically used. So if, for instance, there's an easement for access in the back, but you don't see a driveway, you're going to want to ask the seller for a little more information so you can understand what the potential future can hold for that easement. And that's something that you're just going to have to ask about, to investigate. So if there is some sort of auditing the easement, you're going to have to do a little more homework there. It's going to be something beyond just reading the title report and the linked documents to it. Okay, other kinds of issues. So fence disputes. Like I talked about earlier, a fence dispute typically doesn't give rise to a prescriptive easement. So then the only fallback there are equitable easements, and like we talked about earlier, there are situations where a significant fence dispute can allow someone to get an equitable easement. The key is, though, it's going to require some sort of significant use and improvement over the years, not just, oh, the fence is over 5 feet, and I had a little, some plants and stuff there. That typically doesn't do it. It's going to require my pool house or my accessory structure is over the land, or my driveway or my patio that costs X number of dollars. It needs to be something more than just a simple misplaced fence. Trees can oftentimes come into easement disputes, like I talked about earlier. View disputes, trees are relevant there. Ownership of trees is a completely separate issue that's probably more appropriate for another webinar. Property line disputes, again, where does the property end? If there's no fence there, but there's improvements, is that now an equitable easement? And so a lot of times these easement disputes do come up when people realize their property lines aren't where they thought they were. You'd be very surprised to learn how many different properties are actually not proper in terms of where the fences are. In the neighborhoods around here, it's extremely common that a person gets a survey done and every house on the block is a couple feet off. That's not an uncommon thing, and that can cause people to then look into whether they might have gained some easement rights. And lastly is driveways. Obviously, we've talked a lot about access issues. Access issues are significant in the world of easements. And so if you need a driveway, whether you have a right to one, whether by an equitable easement or even by necessity. Okay, these are examples of things that are not easements. So the first is a lot line adjustment. Again, going back to the example of a misplaced fence, can you, instead of just granting some sort of easement, do a lot line adjustment and possibly buy the land from the neighbor because you know that you're not going to be able to win on the prescriptive easement case? That's an option, is doing a lot line adjustment. And that's not an easement. That's actually changing who owns that land. Another issue is adverse possession. So I talked about this a little earlier on prescriptive easements. Adverse possession is the same 4 elements of prescriptive easement, with a 5th element being the payment of the taxes on the disputed land. The payment of the taxes issue is very difficult to prove. So if you're mistakenly encroaching on someone's land, the chances of you being able to prove that you paid the taxes on it are very slim. So there are statutory ways that you can make sure you're paying the taxes. So if you know you're encroaching, you can actually record something and ask the assessor to pay the taxes for that strip of the land. So that's one way. Otherwise, it's very difficult unless you make sort of concerted effort to go ahead and pay the taxes. A lot of the assessors, I've deposed multiple different counties assessors on this exact topic, and they tell me that we don't base our assessments off of the lot lines. We base our assessments off, we don't base the assessments off the fence lines. We base the assessments off of what the lot lines or the property parcel map says. So in order to prove that you pay taxes on something beyond what your parcel map is very difficult because the assessors don't actually go out and measure the lots and making their assessment for tax purposes. They'll go out sometimes. They'll look at comps and they'll just say, okay, this parcel is X square foot large based on our parcel map. That's what we're assessing it based off of. So adverse possession is difficult, but it is possible. And the difference between adverse possession and an easement is adverse possession means you actually get ownership, not just a right to continue using the land. So that land becomes yours. And the last thing is granting a license. So the difference between an easement and a license is a license is freely revocable at any time. So a license is basically just a short-term right to use someone else's land. And also granting a license takes away that hostility element. So this can be a quick and easy way to fix something if it's something that the other side doesn't necessarily need it permanently. You can grant them a license, or if you just want to avoid a dispute, you can grant a license and always revoke it later. Okay, so coming soon, we have created a website. It's CaliforniaEasements.com that has this information, and we'll also do case updates on new issues in the law about easements. We're finding that easement law is just something very big that we've been working on recently. We thought this would be a great resource for our clients and colleagues and friends. So it's CaliforniaEasements.com. It's not live yet. However, if you sign up on the website, if you actually go to CaliforniaEasements.com, we can give you a notification when the website is live if you plug in your contact information. And our goal is to get that live next month. And that's all for today. It's a lot of material to cover in about 45, 50 minutes. Does anyone have any questions? Okay, I have one question here. Can an easement be edited to remove partial rights? Good question. Yeah, easements can always be revised. It's just like any other contract between two homeowners. So say you had an easement that was initially an access and a utility easement. It turns out the person doesn't use it for access anymore and they only need the utilities run through there. Yeah, you can always go back and edit an easement. So it would be a negotiation. The benefited party might say, well, we're giving up a right that we would otherwise have, so you need to pay us a little bit for that or something of the sort. But you can always negotiate these type of things. Just like you can buy an easement, you can sell an easement back. So that's always a possibility, absolutely. Okay, we have a couple questions here about sending us a recording of the webinar. Yes, we can certainly do that. The webinar will be live on our website, so you can actually just physically go onto it and watch the whole thing. And we also can send you the slides if you send us an email asking for it. Okay, we have another question here about PG&E installing a power pole in front of our house before they receive confirmation. Okay, so this is obviously going to depend on what kind of easement you have. So the question is whether PG&E can install a power pole without approval in front of someone's property, and whether there was alternate places to put it, such as the backyard instead of the front. Again, this is going to be completely dependent on what your easement says, what kind of easement you have. And so that's something that you need to look at the language of the easement. Okay, another question. We have a fenced-in parking area adjacent to a 4-unit building. Fenced-in area is on city metro rail line. Has been fenced in and been used for 20 years. Sounds prescriptive, though it is fenced in and hence exclusive. Yeah, so there are difficulties in obtaining easements from governmental entities, first of all. So if it is actually property that's owned by a government, um, and it sounds like it might be, then that's going to be difficult. First of all, that's a hurdle you have. And the fact that it's fenced in does suggest it's exclusive. So that makes a prescriptive easement more difficult, absolutely. So then you have to go to the fallback of an equitable easement. Was it innocent? Did you do it with the belief that you had a right to do it? Have you spent a lot of money and reliance on it? If you lose this, is this going to be a substantial burden to you? And if it remains, is that any sort of hardship on the true owner? So you need to look at those elements, and that's going to be very fact specific about the rights and whether you have other places to park and what the owner is missing out on by this part of land. Next question we have here. What if a city approves an incorrect survey and permits someone to build over onto your property? Okay, again, very fact-specific question, obviously. Um, I don't know how a city could approve an incorrect survey. It might have been an instance where there was some issue with the legal description. I'm frankly going to need more information on that to answer that one. Ultimately, cities have a lot of immunity, but it would depend on what exactly happened and how the survey was incorrect and how that was able to get through the city. Next question here. Is title the best place to determine what type of easement is established? Okay, well, if the question is about an exclusive easement, yes, the title company should be able to pull up a report that has all the encumbrances, and those encumbrances would include the actual easement. So then you need to look at the easement document itself to determine what rights have been granted. And then again, if it's difficult to determine what the scope or the permitted use is, then you might have to look at the historical use to hone in on it a little more closely. Another question, when a municipal government takes a portion of property for a sidewalk, is this an easement and how does this process work? That sounds more akin to some sort of eminent domain issue. Governments have a right to take portions of land with specific qualifications, and they have to pay you for the value of the land and all that. You can't just as a regular homeowner, you can't just say, we're taking your property and we're putting our driveway here. No, you have to be able to establish the other elements. So the government would likely be working on some sort of eminent domain theory in that situation. All right, I'm looking. I do not see any other questions at this time. So I want to thank everyone again for joining. We hope you found this informative. If you have any questions, we are available to help. And if you need a copy of the slides, we will send them over to you. And you can always, of course, watch the webinar again once we get it live on our website, which should be done sometime today, hopefully. So thank you very much, and we appreciate your time.